Welcome to the deep dive, where we take these complex, multi-layered sources, the articles, the court documents, the investigative notes, and we really distill them into the essential knowledge you need to be thoroughly informed and to do it quickly and memorably.
Today, we are immersing ourselves in a case that is, it's far more than a simple tragedy. It's really a landmark legal and political event. It sits squarely at this collision point of, well, family breakdown, entrenched coercive control, and the, I think, flawed application of a psychiatric defense.
And ultimately, an extraordinary confrontation between executive government power and judicial sentencing precedent in the UK.
Exactly.
The subject is the high-profile case of Robert Brown, the former British Airways captain who, on Halloween night 2010, killed his estranged wife, Joanna Simpson. The facts of the crime were just shocking, but the controversy, it truly ignited with the verdict. Brown was acquitted of murder, but convicted of manslaughter.
And on the extremely contentious grounds of diminished responsibility.
Right, and this verdict, it comes back 13 years later to create the system's biggest challenge. I mean, despite really compelling evidence of clear premeditation, you've got a pre-dug grave, a concealed weapon, the systematic suppression of evidence.
And still, he received a standard determinate sentence, which meant he was automatically scheduled for release in 2023, having served precisely half his time.
But that automatic release was blocked. The government, under some intense pressure and using new, pretty untested legislation, intervened. They declared him a continuing public risk, forcing a review by the parole board.
And that move was immediately challenged by Brown in the High Court, which created this crucial legal test. Can the executive branch override a decade-old judicial sentence based on an offender's refusal to reform in prison?
So our mission is to analyze this entire complex sequence. We're going to trace Joanna Simpson's life and the toxic dynamic of wealth and control in the marriage, scrutinize the specific legal decisions and the, narrow psychiatric loophole that Brown exploited.
And then, most crucially, unpack the granular legal arguments used in the High Court to keep him detained. This deep dive is fundamentally about how the law adapts when it's faced with an unrepentant and, frankly, manipulative high-risk offender.
Okay, let's unpack this, starting with the volatile context of the marriage and these financial structures that didn't just fuel resentment, but really provided the map for his coercive control.
To appreciate the explosive nature of the conflict, you have to first understand Joanna Simpson. Born in 1964, she was a success story in her own right. She was educated, driven, independent. She studied business at the University of Bath and established a highly successful 5-star bed and breakfast, Tun Cottage it was called, in Ascot.
And that location, that business, they were so central to her life. Running the B&B gave her financial independence and the flexibility to be what she really cherished most, which was a totally hands-on mother to her 2 children. She built this environment of kindness and stability, grounded in strong moral values.
Friends all said the same thing about her. She was established, secure, and she had very carefully built her own wealth.
Then in 1998, she meets Robert Brown. He presents this authoritative figure, a professional BA captain flying long haul, and he was even a UK trail running champion.
Right. The relationship escalated quickly. There was this grand, almost cinematic proposal while he was flying a plane. They married in February 1999.
But that narrative, that romance, it fractures almost immediately. We see these stark warnings from those closest to Joanna. Her parents, when they met Brown, they just described him as rude and arrogant.
The red flags were not subtle at all, and that sense of foreboding just intensified. Joanna herself called her mother from the honeymoon right after realizing she was pregnant and described the marriage as a terrible mistake. She said she felt instantly trapped.
And the mechanism of that trap, it wasn't just emotional, was it? It was financial. It was engineered years before the conflict even reached a boiling point.
That's right. Joanna's father, who, maybe was sensing danger or maybe just exercising caution because of his daughter's inherited wealth, he insisted on a mandatory prenuptial agreement.
A prenup designed specifically to protect Joanna's trust fund and the asset that really underpinned her independence, Tun Cottage, the family home and the site of her successful business.
And this agreement, even though it was legally executed, it became the nucleus of Robert Brown's deep and what's described as continuing resentment. He had invested a substantial amount, we're talking about £200,000, into the B&B business during the early years.
Believing, I suppose, that this investment guaranteed him a stake in her long-term wealth.
Exactly. But the prenup fundamentally contradicted that belief. So he saw it not as a fair agreement protecting family assets, but as a hostile stitch-up, something that deprived him of the capital he felt he was owed.
This wasn't just a disagreement over money then. It was a deep-seated grievance. It was rooted in this sense of entitlement and perceived injustice, and it gave him the internal justification for all his later coercive behavior.
And that financial resentment, it just became the backdrop for escalating psychological abuse. The sources detail a classic pattern of coercive control. You have isolation, intimidation, manipulation. By 2007, the dynamic was so toxic that Joanna consulted a solicitor.
And that was triggered by Brown's false accusation that she was having an affair.
Right. And the threats Brown made weren't veiled, they were explicit and meticulously detailed. In February 2007, while he was away on a working trip in Hong Kong, he calls Joanna and he lays out his really dark thoughts.
Detailing scenarios where he would kill her and their children with an axe, or maybe commit suicide by crashing an aircraft.
I mean, that is the ultimate form of psychological intimidation. It weaponizes his status, his professional skill, and the safety of their children. It wasn't just an expression of anger, it was a sustained psychological campaign, designed to make Joanna compliant through sheer terror.
And this all culminated in the physical threat of the knife incident later that same year. Brown confronted Joanna, put an arm around her neck, and held a knife to her chest.
And when she finally convinced him to release her and declared she was leaving, his core motive was just laid bare. He told her she could leave, but under no circumstances could she take the children.
He enforced that with a clear threat, didn't he? He said if she told anyone, it would be the worst for her.
It just confirms the violence was fundamentally about control, not impulse. It was about severing her independence and ensuring his continued dominance.
So you have this history of long-term financial grievance, high-risk coercive control, and that sets the stage for the final, sudden impetus for homicide. And this is the crucial legal inflection point, because the trigger wasn't a sudden argument.
No, it was a landmark institutional decision, a court ruling that cemented Joanna's legal victory.
So we know the couple had been locked in this bitter, protracted divorce for over 3 years, all centered on custody and the validity of that prenup. The final court hearing was set for November 8, 2010.
And Brown's entire financial strategy was riding on undermining that prenuptial agreement.
But then, on October 20, 2010, just 11 days before Joanna was murdered, the legal landscape in the UK shifts, irreversibly. The Supreme Court delivers its ruling in Radmacher v. Granatino.
And that case essentially made prenuptial agreements enforceable in UK law as long as they were entered into freely and with independent legal advice.
For Joanna, this ruling must have felt like absolute freedom. She was reportedly ecstatic, immediately calling friends to celebrate that the legal uncertainty was just gone.
The precedent set by Radmacher meant her trust fund and her home were protected. Her strategy had won.
But for Robert Brown, his lifeline had been cut. The whole basis for his 3-year legal fight, that hope that he could still seize the £200,000 he felt entitled to, it just collapsed.
The legal system was about to grant Joanna the finality he had tried for years to prevent through intimidation. And this confluence of factors, years of festering grievance, the habit of coercive control, and the sudden crushing finality of that legal decision, it transformed the threat from psychological warfare into an imminent lethal act. The clock was ticking.
Let's move now to the calculated crime itself, because the physical evidence of the murder and Brown's actions afterwards, they present such a profound and shocking contradiction to the diminished responsibility defense he successfully used.
The incident took place on Sunday, October 31st, 2010, Halloween afternoon at Tun Cottage. Brown arrived to return the children, a boy aged 10 and a girl aged 9, after their half-term visit.
Joanna, perhaps sensing the danger, usually made sure a friend was present for these handovers. But on this day, tragically, she was alone.
And the attack itself was not spontaneous. Brown had arrived armed. He concealed a claw hammer, which he'd taken from his bike shed, inside his daughter's homework bag. He carried it into the house under the pretense of returning school supplies.
The confrontation began shortly after they entered the home. It might have been over something minor, like the children's schooling or eye injury their son had, but the violence was immediate and overwhelming. It happened in the hallway.
Forensic analysis painted a gruesome picture. Joanna Simpson was bludgeoned with what was determined to be heavy force at least 14 times with that hammer. She had severe traumatic injuries, but also clear defensive wounds on her arms and hands. She fought desperately.
And the most terrifying part is that the children were just 2 doors away in the playroom. The 9-year-old daughter, Katie, she later testified to hearing the distinct sounds of the attack, the noise of the struggle.
This was a crime committed not only against Joanna, but in the immediate auditory proximity of her children.
The brutality, the sheer number of blows, it certainly suggests a frenzied loss of control, an act of blind rage. But the minutes immediately following the homicide are what completely confound that diminished responsibility defense. They show extreme organization and cold cognitive function.
That cognitive dissonance is the crux of the legal debate. Brown's post-homicide actions were systematic, efficient, and clearly designed for concealment. First, he wrapped Joanna's body meticulously, probably using plastic sheeting in a surfboard bag, to make sure there were no bloodstains in his car.
He then immediately went to the master bedroom, found the home's CCTV unit, and physically removed it from a cupboard to suppress any visual evidence. I mean, that action speaks directly to forensic awareness and retained control.
And then comes the truly harrowing detail. He drove the 2 young children away from the house, with their mother's body concealed in the boot of the car. He lied to them. He said their mother was unwell and needed to go to the hospital.
Their son, who was 10, even asked on the drive, "Are we going to the hospital?"
He dropped the children off at the home of his pregnant girlfriend, gave a cover story, before turning off his mobile phone and driving to a remote, secluded area of Windsor Great Park. And there, he disposed of Joanna's body.
The police ultimately found her inside a plastic garden box, which was buried in a shallow grave he had pre-dug.
And he took further steps. He buried the claw hammer and the CCTV unit separately. This entire sequence, the wrapping, the evidence suppression, the transportation, the pre-prepared grave, it demonstrates an intent to cover up the crime that flatly contradicts the picture of a mind overwhelmed by temporary stress.
During the trial, Brown tried to rationalize the most damning piece of evidence, that pre-dug grave. He offered this bizarre explanation that the hole in the box were meant as a time capsule to bury court papers and bury the sham of his marriage.
A rationalization that was, a transparent attempt to neutralize the evidence of premeditation. Nevertheless, the jury ultimately accepted his plea. Not guilty to murder, but guilty to manslaughter on the grounds of diminished responsibility.
The success of that defense rested entirely on a specific psychiatric finding. Can you elaborate on the diagnosis the defense used?
Yes, the linchpin was the diagnosis of an adjustment disorder, or AD. The defense psychiatrist argued that Brown was suffering from this condition, which is categorized as a mild, temporary stress-related illness, linked specifically to the intense acrimony and financial pressure of the divorce.
And the nature of an adjustment disorder is so critical here. It is, by definition, considered temporary and generally mild.
Precisely. Medical literature suggests violent outbursts are very rare in cases of AD, and what's more, the defense psychiatrist stated that the disorder was so fleeting that it had disappeared almost immediately after killing his wife. It gave the jury a mechanism to attribute the violent act to a temporary mental malfunction rather than to deep-seated malice or premeditation.
But the prosecution, they had their own psychiatric expert who fundamentally disagreed with all of this.
Dr. Joseph, the prosecution's expert, strongly countered the AD defense. He argued that Brown was fundamentally resilient, intelligent, and logical characteristics you need to be an airline pilot navigating complex stress scenarios all the time. Dr. Joseph suggested Brown was in control and did not meet the necessary legal standard for diminished responsibility.
Which requires that the defendant's ability to, form rational judgment or exercise self-control is substantially impaired?
Exactly. Yet, despite the prosecution's robust argument and the clear evidence of planning the hammer, the grave, the CCTV, the jury accepted the DR defense.
So the charge was reduced from murder to manslaughter. Brown was sentenced to a total of 26 years, 24 for manslaughter, and a consecutive 2 years for obstructing a coroner. That latter charge directly addressing the cover-up.
And while the judge, Cook J., was legally bound by the jury's verdict, his sentencing remarks reveal the court's deep discomfort and really an implied challenge to that finding.
We absolutely need to focus on this judicial caveat. It forms the moral and legal basis for the government's intervention years later.
Judge Cook J. stated explicitly that Brown retained real culpability and substantial responsibility for the killing, notwithstanding the successful DR defense. He made it clear that Brown's conduct went far beyond the transient effects of a stress disorder. And crucially, the judge emphasized that the stressors cited, the divorce, the financial uncertainty, were ones which many people face without resort to violence.
But he did not deem Brown dangerous TTP through time to release, which would have meant an extended or life sentence.
That's the key. Because he didn't apply that designation, Brown was handed a standard determinate sentence, or SDS. And the critical consequence of an SDS in the UK justice system is the automatic statutory right to release on license after serving exactly half the term.
So that finding of retained culpability, coupled with the SDS classification, became the defining tension point of the entire case.
It absolutely is. That judicial finding of retained culpability, that he was still largely responsible, is the ghost that haunted the system 13 years later when Brown was due to walk free.
Under the rules of his SDS, he was scheduled for automatic release on license in November 2023. 13 years served. The system was legally obligated to open the doors.
And this is where the fierce public advocacy campaign, driven by Joanna Simpson's family and friends, really took center stage.
The campaign was led by Joanna's mother, Diana Parks, and her best friend, Hetty Barkworth-Nanton. They correctly identified the systemic loophole, a man deemed to have retained substantial responsibility for a calculated killing, who showed no remorse, was about to be automatically released.
Their public campaign was intense and highly visible. They argued vehemently that Brown remained dangerous, manipulative, and unrehabilitated. They got significant support from domestic abuse advocates, politicians, emphasizing that this was a failure of the system.
A failure to protect the public from high-risk offenders who use a DR defense to secure a standard sentence.
Exactly. Their advocacy targeted that systemic gap. It highlighted the fact that the original judge, based only on the evidence available in 2011, couldn't have possibly foreseen Brown's behavior over the next decade in prison. The system lacked a mechanism to reevaluate that risk based on post-conviction conduct.
And the campaign achieved a major victory. It forced the government to deploy a specific, relatively new and powerful legal tool. What was this mechanism designed to do?
The mechanism is Section 244 ZB of the Criminal Justice Act 2003, which was introduced by the Police, Crime, Sentencing, and Courts Act of 2022. This legislation was enacted precisely to address scenarios like Brown's, this unmanaged risk posed by SDS prisoners whose behavior in custody clearly suggested an enduring danger.
So the law was adapting to the knowledge gain while the offender was incarcerated.
Exactly. S244ZB grants the Secretary of State for Justice, the executive branch, the extraordinary power to actively detain an SDS prisoner past their automatic halfway release date and refer them to the parole board.
And that power is triggered if the Secretary of State, believes on reasonable grounds that the prisoner would pose a significant risk of serious harm.
That's the threshold. It's a lower bar than a judge's requirement, which facilitated the intervention. This sounds like a direct legislative response to the so-called Joanna Simpson loophole, allowing the executive to pause the statutory right to release when new, compelling evidence of risk emerges.
It provides a public safety veto.
It does. The intervention itself came in October 2023. Justice Secretary Alex Chalk exercised this power, blocking Brown's automatic November release and mandating a full risk assessment by the parole board.
Chalk publicly affirmed his commitment, saying the decision was made to protect the public based on the available up-to-date information regarding Brown's conduct and attitude in prison. This decision directly overrode Brown's statutory right to release.
And Brown immediately challenged this decision via judicial review in the High Court. His lawyers argued the Secretary of State was acting unlawfully, disrespecting the original judicial finding, and was unduly influenced by the media and political campaign.
They claimed the decision was motivated by conscious or unconscious political bias, turning a legal process into a political one.
Right. They argued the SOS was improperly trying to go behind Judge Cook's 2011 finding that Brown was not dangerous TTP.
So how did the Ministry of Justice counter this? If they weren't disrespecting the original sentence, what was their core evidence for claiming Brown was now a significant risk?
The Ministry of Justice conceded they weren't challenging the 2011 verdict. Instead, they argued they were relying entirely on new or additional information, namely, Brown's sustained, willful, and obstructive behavior throughout his 13 years of incarceration. They argued this post-conviction conduct, which the sentencing judge couldn't have known, demonstrated a profound and unaddressed pathology.
Okay, let's get into the specifics of that new information, because this is the core of the risk assessment. What did the prison and probation service reports actually show?
The evidence was built on two interconnected pillars of psychological rigidity, which were documented extensively in reports from the Offender Assessment System OASIS and the National Security Division.
And the first pillar was Brown's profound and unshakable lack of insight into his own crime.
Absolutely. He consistently refused to acknowledge his retained culpability, that high level of blame the judge assigned him. He maintained this rigid, denial-based narrative. His actions were entirely and exclusively due to the temporary adjustment disorder.
Which, since it resolved immediately after the killing, meant he posed no risk whatsoever in his mind.
Exactly. And this sounds like more than just denial. It's an intellectual refusal to engage with the actual psychological drivers of his violence. And this rigidity prevented any meaningful therapeutic intervention. If he believes the crime was solely the product of a temporary medical condition that vanished, then he has no need to explore the underlying issues of control, entitlement, or grievance.
And this leads directly to the second pillar. His comprehensive refusal to engage with any professional efforts designed to assess or reduce his risk over 13 years.
This was the most damning evidence. Despite his high-risk categorization, Brown never completed an offending behavior program. He declined all requests to participate in psychological risk assessment.
What were the prison professionals actually saying about his attitude?
The reports described his demeanor as consistently hostile, superior, defensive, dismissive, and grandiose. He treated the professionals, the very people trying to assess his fitness for release, with contempt. For example, when a forensic psychologist requested his consent to conduct a formal risk assessment in July 2023, he was described as defensive and abrupt. He stated he believed the adjustment disorder only lasts 6 months and immediately threatened legal action, effectively blocking the entire process.
He was systematically and intentionally obstructing the very system designed to prove he was safe for release.
Precisely. This lack of engagement meant the professionals had no data, no insight, no basis to demonstrate that his risk factors had decreased. So, based on his underlying pathology and refusal to cooperate, they had no choice but to assess him as a continuing high risk of serious harm to future female partners.
So the Secretary of State had clear evidence that Brown's psychological drivers, this ruminative, angry grievance-type thinking, remained unaddressed and unchecked. This is what the Ministry of Justice presented to the High Court as the reasonable grounds for their belief.
Let's turn now to the High Court ruling delivered by Mr. Justice Ritchie in February 2024, which dismissed Brown's claim on every single ground. How did the judge address that core statutory requirement that Brown posed a significant risk?
Judge Ritchie found that the Secretary of State had entirely reasonable grounds for this belief. The OAC system, which is the official risk classification tool, had categorized Brown as high risk to children and high risk to the public. The judge noted that the word significant in the law means noteworthy, of considerable amount or importance. He ruled that the unchallenged professional assessment of high risk met that criterion.
But this brings us to the most complex and nuanced point of the entire review. Brown's argument that the Secretary of State was acting contrary to his own published policy.
This was his strongest legal point.
Right.
The internal policy stipulated that referrals should generally be restricted to prisoners assessed as very high risk, a classification meaning the dangerous event is more likely than not to happen imminently.
And Brown was classified as high risk, but crucially, his risk was not deemed imminent because he didn't currently have an intimate partner while in custody.
So if he didn't meet the very high risk and imminence policy thresholds, why did Judge Ritchie uphold the decision, acknowledging that it was a departure from internal policy? What was the legal justification for this being an exceptional case?
The justification hinged entirely on Brown's act of sabotage. Judge Ritchie ruled that Brown himself had provided the good reason to depart from that internal policy threshold.
That is a remarkable legal conclusion. How did the judge link Brown's behavior to the policy failure?
The judge explained that the OAC system, and specifically the imminence factor, relies fundamentally on the cooperation of the prisoner to conduct psychological testing and develop risk management plans. Brown, by refusing to engage for 13 years, had substantially undermined or frustrated the imminence part of the risk assessment system.
So in effect, because he successfully blocked the very assessments that would determine when or how his risk might manifest, he made it impossible for the system to definitively assess the risk as non-imminent.
Exactly. The High Court validated the principle that willful obstruction is, in itself, a high-risk behavior and a valid justification for executive intervention. Judge Ritchie issued a sharp legal rebuke, stating that since Brown had effectively disabled the system designed to assess him, it ill behooves such a prisoner to rely on the blocked or undermined OSI assessments.
This judgment fundamentally shifts the burden. It says, if you refuse to prove you are safe, we must assume the highest level of risk.
It was a crucial, defining moment. It confirmed that the government could depart from its own strict internal policy if the prisoner's conduct made adherence to that policy fundamentally impossible or unsafe. Public protection necessitated action in the face of Brown's self-inflicted data vacuum.
What about the politically charged aspect? Brown's claim that the decision was driven by bad faith because of the intense public campaign.
The High Court conducted a thorough review, looking specifically for evidence of bias or undue pressure. And while the judge acknowledged that the high-profile nature of the campaign was why the Secretary of State personally took the decision, he found no evidence of political bias influencing the final substantive decision.
So the judge was satisfied that the Secretary of State, quote, expressly made it clear that he did not take any campaign matters into account when assessing the legal criteria. The decision was based strictly on the factual evidence of Brown's post-conviction conduct.
Right, and his failure to address the retained culpability, which was a clear indicator of enduring pathology, the court thus affirmed the integrity of the legal process.
The immediate practical result of this ruling was that Brown remained fully detained. It affirmed, legally and unequivocally, the utility of this new S-244ZB power to compel parole board scrutiny for high-risk offenders who demonstrate enduring dangerousness in custody, regardless of their original sentencing classification.
It provided a necessary mechanism to scrutinize the unrehabilitated coercive controller, the type of offender who often presents as compliant but lacks true insight. The kind of person shielded from an indeterminate sentence by a specific temporary diagnosis a jury accepted years ago.
Shifting our focus now, let's consider the lasting human and policy legacy of this case, particularly for the forgotten victims of domestic homicide.
The human tragedy is profound and long-lasting. The impact on Joanna Simpson's two young children, who were present during the attack and then transported with their mother's body in the car, represents an extreme compounded trauma. They're rightly often referred to as the primary forgotten victims in these cases.
And Joanna's memory and her values of protection and security have been channeled into effective national action. Her mother, Diana Parks, and best friend, Hetty Barkworth-Nanton, co-founded the Joanna Simpson Foundation in 2014.
And the Foundation's mission is highly focused and deeply personal: to transform the care, support, and protection of children affected by domestic abuse and homicide. They strive to provide a safe, secure, and loving environment for children navigating these crises.
The statistics they advocate with really demonstrate the scale of this crisis. They note that approximately 200 children are bereaved through homicide every year, and a staggering 130,000 children are in households categorized as being at risk of serious injury or death from domestic abuse.
The Foundation has successfully transformed a personal tragedy into a national policy priority. Their immense advocacy work culminated in both Diana Parks and Hetty Barkworth-Nanton being awarded CBEs in the 2024 New Year Honors for their crucial services to vulnerable children.
And looking at the criminology and legal implications, this case provides a perfect, albeit devastating case study of the tension between instrumental violence, the planning and control, and the successful deployment of psychiatric mitigation.
Criminologically, Brown's behavior, the pre-dug grave, the evidence suppression, the rationalization of his actions are textbook elements of instrumental violence, typical of a high-power coercive controller whose sense of entitlement is shattered by a loss of control. He was executing a final, calculated act of dominance.
Yet, the successful defense of diminished responsibility, based on this mild temporary adjustment disorder, it risks minimizing the true nature of that calculated, enduring control. It allowed a high-risk offender to avoid the kind of indeterminate sentence that would have automatically compelled continuous parole board review.
And this is where the new S.244ZB power becomes the critical legal safety net. It means that the executive branch can now formally reevaluate enduring risk based specifically on an offender's post-conviction behavior and attitude, a form of knowledge that transcends the original jury verdict.
The critical shift is that Brown's refusal to participate in rehabilitation or gain insight is now recognized in law as a valid, tangible indicator of continuing dangerousness. It outweighs his automatic right to release under the previous rules.
The High Court judgment affirmed that the evidence of Brown's systematic denial, His complete lack of insight into his retained culpability and his active unwillingness to change over 13 years was sufficient legal justification for executive intervention. This ensures public protection is the ultimate priority, even when it means challenging established statutory release rights.
So what does this all mean for you?
It means that the legal system has demonstrated a capacity to learn from past tragedies and close specific gaps concerning the management of high-risk domestic offenders. The law is now equipped to deal with the manipulative, unrepentant individual who tries to exploit legal structures to regain freedom. The knowledge gained about an offender's ongoing pathology in custody is now given significant weight in law, acting as a crucial check on automatic release entitlements.
That leads us to our final thought. The High Court found Brown's lack of insight into his retained culpability was the central danger sign, and his active refusal to engage made the risk assessments inherently unreliable. If a dangerous individual intentionally blocks all attempts to assess and manage their risk while incarcerated, should the burden of proof effectively shift entirely, automatically compelling the parole board to operate under the assumption of the highest level of risk upon release, simply because the prisoner has successfully sabotaged the very system designed to prove they are safe.
It raises a powerful question about agency, manipulation, and responsibility within the correctional framework. It asks whether we should legislate against the willful obstruction of rehabilitation as a high-risk factor in its own right, forcing the individual to cooperate or remain detained indefinitely until they do.